Welcome back, everyone. As a dispute resolution institution center, IAMC has been fortunate to have seen its mediation practice gain traction from day one when compared to arbitration. In light of the same, to keep this momentum going, on this first India Mediation Day, please welcome our live trustees, Hon'ble Mr. Justice L. Nageshwarrao Garu and Hon'ble Mr. Justice R.V. Raveendran Garu as they chart out the future of mediation at IAMC. I would like Mr. Romit, the mediator for this session, to take forward the discussion. The floor is all yours now. Thank you.
Thank you very much, Sunena. Welcome back, everybody. We've just had lunch. And as you know, it's important to be fueled and be ready to go. So we're now here to look at what we are going to do in the next 2 years, our vision till 2025 for mediation. And we'll start off with a very, very simple question to our live trustees. Justice Rao, Justice Raveendran, what were your expectations regarding mediation when you set up the center? And what sort of progress have we made so far in meeting any of those goals?
You're all fueled to sit here. I hope we won't lull you into sleep. We just have about half an hour, and we'll try to be brief in what we are going to speak about. Answering your question, Romit, I should confess that initially we didn't have too many expectations about mediation when we started this center. To start with, as I was speaking in the morning, we were thinking of an international arbitration center. And when we were forming the governing council, there was a suggestion that was made that this center should not be restricted to arbitration, and mediation also should be included. Then we roped in Chitra, who's a professional mediator. And she was the one who framed the mediation rules for the center, working along with Justice Raveendran. And then we found that mediation is as important as arbitration, and we need not restrict ourselves to arbitration. But looking at the work that we have done during the past almost 1.5 years after the center has started, the center has done more work on mediation than arbitration. We also realize the potential of mediation being a very effective alternate dispute resolution mechanism. And we also thought that mediation should be given importance not only at the level of Hyderabad, but we thought that we should also ensure that the mediation is taken up seriously even at the mofsil levels. This state has about 31 districts, and there are bars in all the districts. Justice Raveendran especially was very much interested in the center serving the state, because the state government was very cooperative initially for the center being started, and thereafter the support it was giving. We thought that whatever we do, we have to focus on Telangana state first and see to it that the legal professionals in the state of Telangana also are part of a dispute resolution process. In that direction, we had conducted certain training programs for lawyers from the districts at our center. And we were also coming forward to hold sessions even for judges. There was a one-day program that we have conducted. Justice Hima Kohli and me, we participated in that. Justice Raveendran couldn't come because he was slightly indisposed on that day. We had a full day training or awareness for all the mofsil judges of this state, trying to tell them the need of referrals, because judges referring matters for mediation is of great importance. But as I see the future as to how mediation should take off, I do not want mediation, I in the sense I'm speaking for the institution itself, to be restricted only to legal professionals. I gave an indication of this in the morning when I was speaking. Why should the mediators only be from the legal profession? Actually, mediation should be across sections of the society, is what we perceive. So when we are speaking of training, yesterday the persons who came for training were mostly from a background of law. Either they be senior advocates practicing in the High Court, or persons who are general counsel working in corporate law firms, or even persons who have come from the industry. Most of them have a legal background. We should think of persons even without a legal background coming from the industry, coming from various other sectors of the society, sections of the society. They would also make very good mediators. The idea is that we have to propagate the idea of mediation. The mindset has to change, that mediation should not be taken lightly. I will tell you my own personal experience having been a judge. Matters that were coming to us, if it's a matrimonial matter, we say it's all right, why don't you try, why don't you get this matter mediated, even after 10 years or 15 years of litigation. A property dispute within the family or between the siblings, even there also we used to take the lead. But a commercial matter, there was some sort of a mind block even for the judges to refer the matter for mediation. That is because we know that the matter is going to come back without being settled. So persons in the society have to be aware that even a complicated dispute can be settled, like the disputes that are settled by the SIMC, complicated commercial disputes. Once we are able to change the mindset of people, then I think things will fall in place. So the institution will definitely work for more training programs, awareness programs amongst the society, that mediation should be taken up seriously.
Thank you so much, Ashish Rao. It's safe to say that at our center, mediation doesn't play second fiddle to anything else. But building on your response, sir, we have some idea of where you would like to take mediation as a tool, not just for lawyers, but anybody else. Justice Raveendran, where does IAMC's mediation promotion strategy lie? Are we trying to fill a gap in the market where mediation is becoming mandatory in many commercial concerns? Or is there also a push for expanding access to justice, bringing mediation to people who otherwise have a bit of legal poverty, when they're not able to exercise their rights? What is the approach that the center is going to take in this regard? It's on screen.
Firstly, don't be misled by the name International Arbitration and Mediation Center. This is not a 5-star facility. This is for the society, for the people of Telangana. This is first thing we want to see. Incidentally, if international arbitrations and international mediations we are able to get and give service, we will do it. But basically, it is service to the society, service to the people of Telangana. This we should remember. Second, if you are serving, you can serve one field, or you can put your feet wide, ending up not serving anyone. See, if you want to do serving the what you term as legal poverty, persons who are financially not sound and who do not have access to justice, you want to provide. See, we can do it. We would like to help everyone. It is like saying that a judge saying that let there be light. There cannot be light because he says, or let the poverty be wiped out. It is not possible. You have to concentrate. Now, our center is concentrating on commercial disputes. Now, in regard to other disputes, where you say for the weaker section, financially weaker section, the persons who can render ideal service are the state legal services authorities. You have the State Legal Service Authority, you have the District Legal Service Authority, you have the Taluk level Legal Service Authority, where legal aid is provided, and Lok Adalats are conducted, where the disputes are not complicated and the disputes are small, or they can be, justice can be delivered to them. So we are concentrating on a particular sector. In the commercial dispute area, we are willing to serve everyone. We are not going to say 1 billion claim or 1 million claim or 100 rupees claim. If it is a commercial matter, and if they come to us, and if the fixed charges, whatever charges we have fixed or given, we will serve. In fact, it was set up, it was a thought in the mind of Justice Nageshwar Rao. When it was shared with Justice Ramana, he had the vision to let us establish an arbitration and mediation center. And when this was put forth to the government, the Chief Minister and the other ministers, including the Law Minister, had the vision to think not about the immediate benefits, but about the benefits in the long run to the society, and making it attractive for investment, foreign investment. All this they have considered. Therefore, we now have started with the infrastructure. First we had the infrastructure, nothing. We started with nothing. We have a wonderful infrastructure now. We are going to have better infrastructure. Then we found that we did not have mediators. So we started training mediators. First we trained the local Telangana lawyers by our local trainers, not from local trainers from Delhi, from Chennai, who are all here. And then we have now given training, we have taken the next step. We have trained by getting the international trainers, keeping in view the international mediation in mind. So we are going step by step. Infrastructure, yes. Next is having the basic need, that is having the minimum number of mediators who are well trained. That we have done. Next we have gone to international arena for training. That's we have done. Now the center is in talks with the government. Government has agreed that all MSME disputes which are hanging in for years together in arbitrations and mediations will be referred to the center. And the center has agreed to do it. There I can answer the question, legal poverty. If a MSME has a small dispute of 1 lakh also, we will take it up. We will provide the infrastructure. Therefore, the idea is we provide the basic infrastructure, we provide the mediator, the personnel, then we try to get the work, we get the work state within the state, and we hope to get, once we establish our credibility, which is the most important thing in any this thing, like IAMC has established the credibility. We establish the credibility, people will automatically come. If you do not have the credibility, howsoever you try, people are not going to come. So our next step is establishing the credibility of this institution. It will be neutral, it will not favor anyone. Though it is supported by the government, it is only for the purpose of establishing, it is totally autonomous, it will work for the people. Now that's what we want to establish. We are looking forward, and the bar, the Hyderabad bar has come forward to help. Even the Moffisil bar, sufficient number of people have come. Therefore we are sure that we have the potential for giving service, and we are not going to restrict ourselves to international arbitrations or big names. We are going to serve everyone. Yeah?
Thank you for that, sir. Now, mediation as a tool is very often useful not just for dispute resolution, but dispute prevention as well. Are there any thoughts that you have, Justice Rao, with regard to the center expanding its offering of services to something like deal mediation as well, for example?
Can conflicts be avoided in life? I ask myself this question, and then the answer would be it's very difficult to avoid conflicts. You have conflicts in your daily life, in your domestic life, in your dealings with others. And if conflicts can be avoided, what will happen to the 25 lakh lawyers in this country? They might be rendered jobless.
And the mediators.
But there is a theory and practice of deal mediation. I hope most of you would have heard about it. From 2007, 2008 onwards. It started off in Netherlands and thereafter it is being practiced in other countries also, where when there is a commercial contract or an agreement that is being entered into, they take the help of mediators. So in India, you must have heard that when an industry or a company or a corporation wants to enter into a contract, it goes to a big law firm and then takes their help as to what should be the clauses relating to the dispute resolution especially, and where would they be on a strong footing when they're entering into an agreement with the other party. But for the past 15 years, there was an idea that if you associate the mediators at the stage of making the deals, so the mediator would not be a unidimensional person like a lawyer assisting his company or the corporate, telling them that this is the only way you'll have an upper hand in this deal. But a mediator plays a more important role at that stage, not only speaking to one party, but speaking to the other party also and trying to find out where there is a chance of prevention of a dispute at a later point of time. Though as much as it is desirable that you have people from the other professions or other walks of life apart from the legal profession, mainly the assistance of legal professionals is taken by the corporates or persons who are entering into deals. A legal professional is actually changing roles rather. A legal professional is seen to be a conflict manager now. The modern thought is that a legal professional manages conflicts. Need not be a person who settles disputes, but he manages conflicts. In the sense, managing conflicts also includes prevention of disputes. Though it might not work well, but otherwise we have sufficient work. I was just speaking to Gregory during lunch. We have almost 50 million cases here. So by preventing a dispute happening, nobody is going to lose, but that's not how people from the legal profession think. Even I was a part of it till recently. So deal mediation is something which is new to this country. We are really not introduced to deal mediation. I would definitely venture into this area, and if I can have help from SIMC, at some point of time, we would want them to come here and then when they are doing the training, deal with deal mediation also. If we have some corporates coming in, and if they can definitely think about this, that you have a mediator between two parties entering into a contract. See, all of us know when you enter into a contract, you're really not concerned about what's going to happen in the future. If people think about it, most of the disputes can be stopped. But you're in a haste into entering into an agreement, you don't think on all fours as to what are going to be the problems in the future. But if there is a mediator at that stage, tells party A, so this is what you're going to get out of this deal, and tells party B, this might be a problem. And it is also said in this deal mediation, a person who has acted as a mediator at the initial stages when the deal is being made would be a better person to resolve the dispute as a mediator as and when, not resolve the dispute, settle the dispute as and when a dispute arises between parties at a later point of time, because he knows right from the beginning as to what were the terms which have been talked about at that stage. This is at a very nascent stage. Deal mediation is something which is absolutely new to our country. But if at all there is an opportunity, we would definitely like to take the help of SIMC and other persons who are well versed with it, and then tell the industry that if there is a chance, avoid conflict. I remember at a fireside chat about 6 or 7 months back with the industry, I didn't use the word deal mediation. I was speaking to the industry and I told them that you should have professionals working in your company or your corporate firm where they'll tell you, oh, this is where it is going to go. And if we do this, then there might be a problem. So if you get the help of a professional there, you might be avoiding conflicts later. So we are open to this deal mediation being also made popular with the help of some professionals.
Thank you for that, sir. I think that's a very exciting future that we're setting up in expanding the scope of what mediation can do for people. Now, in terms of, we're linking this back to the previous panel really, but Justice Raveendran, do you feel that a fixed fee for mediators, consider for example the fee schedule that IAMC has, is something that is sufficient to incentivize young professionals who are finding their feet in this field, which is very much still growing and developing? And should there in fact be a flat fee for mediation services, regardless of the number of parties in a dispute or the complexity that a dispute may entail?
The question, I suppose, presupposes or assumes that the fee structure is not good. That's what you have assumed. Well, I have two answers. We have a young mediator. You are asking about young mediator getting a smaller fee according to you. We have a young mediator. We have a center. So we have a center. We have mediators, but we do not have one. Now, you are thinking only about the mediator. The mediation center and the mediator are meant to serve the person who is having a dispute. I would not call it as call him as a litigant because it is referred to court. A person having a dispute. Now, our primary object is to attract that person to have faith in the system and come to the center and have it settled. Now, if you make the fees high, he's not going to come. First, we should have business, na. See, you know what these MNCs do. MNCs, they come. What is the market? What is the price? 10 rupees. So what they will do? 6 rupees. I will sell it at 6 rupees, 5 rupees. 1 year, you destroy the entire local market. Then whatever they fix is the fee. We are not going to do it. Let me tell you. But we first want persons with disputes. Once we have sufficient number of persons clamoring for services of the society, of the center and of our mediators, we will increase the fees, don't worry. Until then, do it pro bono. Don't even look for these fees. The youngsters should learn. How do they learn? You know, how do they learn? In medicines, they give corpses. They don't give living this thing. It is unfortunate, yes, but you are not that experienced. And the schedule shows, if you are an experienced mediator, if you are a renowned mediator, you can fix your own fees. Then this will not apply. Therefore, we are presently looking at a system holistically. We have a center. We want footfalls. See, that is, first thing is footfalls. Once people start coming, using our facilities, we can increase the fee, we can modify the fees, we can do whatever we want. Until then, let the young mediators suffer a little, but they will be gaining experience, and that experience which they gain will give them the reward later. Therefore, please don't think that the fees is less, and we are very conscious. There is another factor you should remember. If it is an arbitrator with a fixed fee, he conducts the case for 1 year, 2 years, 3 years. But a mediator, on an average, works on a small case. We are now looking at small fee cases. Small cases on 1 day or 2 days or maximum 3 or 4 sittings. Therefore, please don't compare the fees of arbitrators with the mediator. Mediation work is different. The arbitration work is different. Arbitrators like court judges, they have to read. They have to write an award. Mediator need not write an award. It is only, facilitating. So you are doing your work, you should get a good fee. I fully agree. It should be respectful fee. But at the same time, allow us to sit. Then we will stand. Okay? Thank you.
Thank you. Thank you. So what Justice Raveendran has really hinted at for us is the critical need to have an ecosystem that is able to support the practice of mediation. And with that in mind, Justice Rao, would you like to tell our audience about some of the efforts that IAMC has put together in the last year or so in terms of building capacity and developing a network that can support mediators and practitioners?
When we speak of ecosystem, first I should speak about arbitration in this country. In December 2021, when we started the center, there was a big function. There were about 500-600 people who came. At least 5 persons walked up to me to say that they have international arbitrations which are in Singapore. Then I asked them, is there any chance of your future disputes being sent to this center? Because now that we have started this international arbitration center. They said that even if we believe you, that you have a good panel of arbitrators, and then you will be very impartial, and then you will be effective, it will also be fast. But what about the courts? So once you pass an award, there is a section 34, section 37, and thereafter the Supreme Court, we do not know how many years this arbitration is going to take. The question of ecosystem in an arbitration comes there. Whatever the center does, it can't thrive on its own unless the ecosystem is also changed. Fortunately, that problem is not there for mediation. We do not have any intervention of courts insofar as mediation is concerned. You have 2 parties walking up to you as an institution where you have robust mechanism of rules asking for their dispute to be mediated. And the ecosystem that we think of developing surrounding this also depends upon the number of trained mediators that are available. Just before my retirement, about 10 months back, I was the chairman of the MCPC in Supreme Court. That is the Mediation and Conciliation Project Center, which is the apex body taking care of mediations in this country. As the chairman, I was being informed by the registrar that there are several requests for master trainers being sent to their states to train persons. I was given a list at that point of time that there were only about 58 or 59 master trainers who actually had the qualifications which were set out according to the rules that were framed by the Supreme Court. So I was surprised, I was shocked as to how only 58 people can travel the length and breadth of this country trying to cater to the requests made by the high courts as well as the district courts for training. So the most important thing which I thought at that point of time, which I find very relevant today, is that you need to train persons to be good mediators. There's a lack of trained mediators. I'm very sorry to say this. Even court-annexed mediation centers like the Supreme Court Mediation Center also, you have people who are not properly trained. I also do not want to say this, but I want to express myself. There are a number of private training institutes in this country, and persons who are trained by them are not really properly trained. So I hope that the mediation bill goes through. There is accreditation of all these training centers, and the training would be a proper training. I used to hear complaints from clients as well as lawyers in the manner in which even at this stage mediators take up cases in the Supreme Court. What we envisage for the future is, as Justice Raveendran was saying, we want to focus on the legal profession, not only restricted to the High Court but in the districts as well. we want to have a vigorous training for youngsters so that they will make people aware of the importance of training. Actually, the society lives in the districts and in the mofusils insofar as the legal profession is concerned, not in the high courts. You will have to somehow or the other spread this awareness that every case need not go to court. And every dispute which goes to court, you know what happens in this country. There is a way of resolving your disputes to mediation. So we, in this center, though we do not have a specific program as of now, we definitely are thinking of capacity building in the shape of having more number of mediators by taking up this training. As I was saying in the morning, the High Court judges are going to have a training from May 1st to May 3rd, 3 days. They themselves have come forward to say that we want to learn more about the mediation. They have taken up this initiative. This definitely is going to percolate downwards. So we say that from this center, we are there to help you. We are going to give you a helping hand insofar as mediation is concerned, as to how the awareness is created, as to how the propaganda is there that mediation is the best method for resolution of disputes. As was being discussed from morning onwards, whether you resolve your dispute or not is not the question. The effort that you have made in making two people meet, that makes a lot of difference. I'm in the midst of a mediation of a royal family. People who haven't seen each other, spoke to each other for the past 40 years. During 3 hearings which I have conducted, they have been sitting and talking for 2 hours, and they were thanking me whether we settle this dispute or not. We thank you so much that I've seen my uncle after 25 years. I've spoken to my cousin after 25 years. The dispute has been going on for 40 years. This is the richest family in the country. It almost came to a breaking stage on the last hearing I had 3 days back. I just asked them to think about it and come back to me, but I said that even if you're not going to settle, I'm happy. Now that you have spoken, you have exchanged numbers. In the future, think about it. But they said we will still consider. As JP Singh was saying in the morning, this is the intent with which mediation is held. You might not succeed in every case, but definitely I feel proud that I have made 2 warring families sit together and then speak for about an hour every day on 4 occasions when I met. So this is something which comes from experts like SIMC or other master mediators. We will definitely improve these mediation trainings. We'll increase the number of trainings that are held, and we're not going to stop with lawyers. As I said, the most important thing is we're going to go into the other professions also. We want people from all walks of life to take up mediation. That's the idea for the present.
There is something that we picked up during the SIMC training that was conducted over the past 2 days, which is that the mediator you were 5 years ago is not the mediator you are today. So in terms of having quality trainers and developing yourself as a mediator, I hope that nobody in this room stops at doing just a 40-hour program. There's a bit of continuous upskilling and lifelong learning for us there. And I hope that all of us are able to wholeheartedly embrace that. But keeping all of that in mind, there is, I think, something that everybody in this room would really like to know, because a part of my duties at the center is case management. And we get a lot of inquiries about what is the empanelment process that the center has. Justice Raveendran, so far, we don't have a published list of mediators that is available. Is this something that you feel has worked to the benefit of the center so far, and would we be at any point in the near future having an accessible list of mediators for people to take a look at?
Frankly, not having a list, it means the vessel is empty. You see, for having a list, we should have quality mediators who will get credibility to the institution. You cannot just say, whoever wants to be a mediator, give your names, we will have the list. Now, that is one way of doing it. Of course, we can do that also because it's a kind of a public institution. We cannot discriminate. Somebody who says, I am a mediator, I am a certified mediator, I want to, maybe, we do not know. We may have such a list. Or we may undertake a process. For example, SIMC, it does not just make all Tom, Dicks and Harris mediators or arbitrators. For you have to undergo a process of, I would not say selection, but a process where you are verified, scrutinized. Now that will come in when we have sufficient number of mediators and when we have sufficient work. As I said, let us first get work, and then once we start getting work, we will look into this. Certainly we are going to have this list. This is a very tricky situation. In fact, this is connected to the earlier question regarding fees. See, there are perceptions from fees or this kind of empanelment and all that. When I was in the Supreme Court, you know, some of the judges, we found that there were very few senior counsel. And you know, the senior counsel were, whatever they said was the fees. Even in those days, the top lawyers were charging 1 crore of rupees per day. There were such lawyers. And I went and spoke to Justice Balakrishnan, who was our Chief Justice, along with 2-3 other brother judges, and we said, how do we make it accessible, the services of senior lawyers available to the litigants, so that they have the satisfaction that their case have been put forward by senior counsel who are recognized as leaders of the bar and who are good at presenting the cases, if the fees level are this. After discussion, we decided only way to do it is increase the number of senior counsel. We added, let us say if there were 50 at that time, another 50 or so, and immediately after that, I met one of the newly appointed, newly designated senior counsel about what he thinks. Our idea was, if we increase the number of senior counsel, the fee structure of senior counsel will come down, and availability of seniors will be better, affordable. Now, when I met this senior counsel, I said, how are you, how is it? Yes, he said very happily, sir, now I can charge like senior counsel. See the perception. Our perception was to bring down the fees so that more number of people can have affordable access to senior counsel. The mindset and perception of this person who was made the senior counsel was not to be happy to be available for more number of litigants, but now he can charge more like senior counsel. Therefore, when we come to the question of fees, question of empanelment, we have to be very careful because, for example, in the case of the higher level of mediators, we don't want to fix the fee. We want to leave it to, we will only take the administration fee and make the mediators themselves fix the fee. But for the smaller cases, we cannot afford to, have them charging higher fees. Therefore, I think the market forces will adjust themselves, and after some time, looking to the number of cases, looking to the number of available mediators, and the standard of those available mediators, we may be able to fix appropriate balance.
Thank you so much, Justice Rao, Justice Raveendran.
Make one statement about senior counsel which Justice Raveendran was speaking about. What he said is perfectly right in the context in which he was talking. Now we have applications from about 350 lawyers asking for designation, which have been pending for the past 2 years in the Supreme Court because the court doesn't know how to handle these applications. And we have lawyers visiting judges' houses almost on a weekly basis. What he said is right. It's not as if you're going to bring down the fee of the other seniors who are really doing well. There's a disparity. There's a disparity like in the society. You have the top senior counsel who would not be affected even by the other persons who are made. I remember Justice Kirpal was sitting in court too, and there was a gentleman who was fighting for his designation in the Delhi High Court. He came and then said that why is it that I'm not being made a senior counsel? I've applied almost 5 times and all idiots have been made senior counsel. I'm not being made. Then Justice Kirpal said, Mr. Keshwani, you needn't bother if you're not being made a senior counsel. A monkey is a monkey even if he's a senior counsel.
With that, I would...
We dealt with this problem in Bangalore in a different way. See, there were a lot of applications. And you know, these counts, the advocates were coming and harassing the judges, canvassing with them and all that. One Chief Justice recently thought, why should I get into the bad books of all these people? How many applications? He said, 58. Make all of them senior counsel. Let us see. So all are senior counsel in.
Well, with that, it's time to wrap up our panel. Please join me in extending our thanks to Justice Rao and Justice Raveendran. There's the momentous.
We are the givers of momentum, not receivers of.
And yet they continue to give back as our life trustees, and for that we're very grateful. We stand on the shoulders of giants at IMC. Thank you very much.
Thank you very much. Yeah, the next.